Mr. Lavity, do you want an attorney in this case? No, you don't want an attorney? There are a few things that I need to go over with you then if you wish to represent yourself in this case. In the past, you have refused to participate in that sort of colloquy. Are you going to participate in this colloquy today so that I can make a determination about whether or not you can represent yourself in this matter?
It'll be as you say.
Sorry?
It will be as you say.
Okay. I have to ask you several questions and I need you to answer those questions. Are you going to answer my questions today?
Not at this present time. I would like to ask you something.
Well, we're not here to have.
I'm here because you're forcing me to be here.
Okay.
I've suffered a traumatic brain injury, Your Honor.
Okay.
What's your excuse?
I have no excuse,
Exactly.
Mr. Lavity.
So in order for you to punish me according to your rules, regulation, codes, procedures, and statutes, which have been established on a half-truth, which makes them a whole lie,
Right.
I do wish not to participate. I would like to establish the facts of the matter. Okay? I had a drunken man enter my home.
Mr. Lavity, stop talking. I don't.
Or what? What are you going to do?
Mr. Lavity.
Look, Your Honor, this is what your officers are doing to me. I don't even have this. Okay, I can't. Okay, let me get into. Let me put my leg back in the shackle. Let me put my shackle back in. Okay, but look at Your Honor. This chain is not even properly suited on me, and I'm being attacked.
Mr. Lavity, just stop talking right now,
I'm being
okay?
attacked right now for the officers who can't even do the job and put the damn thing on properly.
Sit down.
Mr. Lavity, I don't want you to make statements that will prejudice you in your case, okay?
I don't have a case.
Mr. Lavity, all that I'm trying to do is you want to represent yourself in this case, right?
Correct.
You don't want an attorney to be
I wish not
appointed.
to be incompetent before the court by giving my liberty to a counsel whose only proper and only reason is to represent the corporate entity.
Okay.
I wish not to participate in that.
And that's fine, Mr. Lavity, but I have to make certain findings before I can find that you have knowingly, voluntarily, and intelligently waived your right to counsel. And in the past, you have acted like this, and other judges have said that they can't make that determination. And so the only thing that I've asked you is whether or not you are willing to participate in this colloquy, this question and answer, to answer my question so that I can make those findings and allow you to represent yourself.
Excuse me, Your Honor. Can I stand up and let these officers put this chain on me correctly?
They don't want you to stand up, Mr. Lavity. They want you to just stay sitting there. And what I would like you to do is to let me know if you're going to answer my questions. Will you participate in this colloquy?
Sure.
Yes. Okay. All right. Mr. Lavity, how old are you?
I don't recall. I believe I'm 57.
You don't recall how old you are?
I don't.
Okay. How far have you gone in school?
I didn't.
You didn't go to school at all?
I graduated.
You graduated high school?
No, I got a diploma.
A high school diploma or a college degree?
I guess it was a GED or whatever.
Okay. Do you read and understand the English language?
That depends.
Well, what does that mean? It depends.
Well, if it's persuasive words and flattery speech meant to beguile the minds of innocent, no, I don't understand. If it's inerrant truth, I understand.
Have you been able to understand me today?
No.
You have not?
No.
Okay. Do you require an interpreter? Do you speak a different language?
I don't believe so.
Okay. Do you take any medications?
I take a multivitamin when I'm at liberty to do so.
Anything about, I infer from that you're not taking that medication currently, is that right?
I'm taking something called doxycycline, I think,
Okay.
and it's for a hair follicle infection, I believe.
Anything about that medication that makes it so that it's hard for you to understand what's going on or to make a clear decision?
I believe not.
Okay. Have you consumed any other medication, drug, or alcohol in the last 24 hours?
Sir, may I have something to drink?
Of course, yes. We can get you some water, Ms. Roberts, or Deputy. Could we get... We'll get you some water here in just a second, Mr. Lavity, okay?
Can we postpone the questions because my mouth's dry and my lips sticking to my teeth?
Of course, yes.
Thank you, Your Honor.
Mr. Lavity, if at any point, I'm more than happy to appoint an attorney to represent you.
I know.
Okay.
But I wish...
And I can appoint an attorney.
Because I'm going to the box because I didn't do what they said I did. Okay.
Again, Mr. Lavity, I don't want you to make any statements that could prejudice you because anything that you say
it doesn't matter.
Can and probably will be used against you.
The whole thing was rigged from the get-go.
Okay.
Okay, from the Mesa Sheriff, the jail, and the parole, and even being accepted into the Hilltop community. Okay, the Hilltop. That's right. This alleged incident happened.
Mr. Lavity, again, you are saying things that relate to your case.
You know what? The truth shall prevail.
Okay.
Okay. Because you can't break the law and in order to force the law.
There's some water for you, Mr. Lavity.
Thank you, Your Honor.
Do you feel like you're thinking clearly today, Mr. Lavity?
I believe so.
Mr. Lavity, do you understand that you have a right to be represented by an attorney in this case?
Forgive me. I understand that if I give my liberty away to a corporate entity who only represents the corporation, I will be received as a lunatic or someone who has lost their mind by the court.
Yeah.
Okay, that's regardless whether you...
None of that is true, Mr. Lavity.
I call BS, Your Honor.
Okay.
Okay. And I wish not.
Do you understand that you have a right to have an attorney in this case?
No.
Okay. Do you understand that because you are in custody, you are entitled to a court-appointed attorney?
No.
Do you understand that I will appoint an attorney at no cost to you?
No.
Do you have any legal training at all?
I've been studying to show myself approved for the last 10 years on a charge that I was sentenced to 10 years in prison that was false. And I did the time and I was supposed to gain my liberty back. And this is the liberty that I got. I'm here before you because of my liberty.
Do you understand that having an attorney would be a great help in preparing and representing any defense that you wish to present in this case?
No.
Do you understand that if you choose to represent yourself, Mr. Lavity, that there would be no special provisions made for you?
Correct.
In other words, you would be expected to know and understand the same laws and the same rules as an attorney would. Do you understand that?
Established on a half-truth?
Do you understand that you would have to abide by the same laws and the same rules as an attorney?
Okay. You filed this affidavit against me.
I didn't file anything, Mr. Lavity.
Whatever. The corporate entity filed this affidavit against me. Okay. I have an affidavit that refutes that affidavit.
There is no corporate entity, Mr. Lavity.
Okay.
Do you understand?
You said that.
Yeah. There is no corporate entity, Mr. Lavity. There is the people of the state of Colorado who are bringing charges against you, and there is you, Mr. Lavity.
Then I would like all the people in the state of Grand Junction or in Colorado here present in this courtroom.
They're represented by Mr. Sullivan in this
That's
case.
persuasive words and flattery speech, Your Honor. Okay, that's beguilement. You know what the root meaning of guile is?
Mr. Lavity, I'm not,
Cunning,
Mr.
skillful
Lavity.
deceit, and I wish not to have it.
Okay.
So let's the truth
Mr.
prevail.
Lavity, I'm not going to debate it with you.
Okay, let truth prevail.
Do you understand that if you choose to represent yourself, you do so at great risk to yourself?
Sure.
Do you understand that you will almost certainly fail to represent your interests as a competent attorney would?
No, because you're calling me ignorant to my face.
No, I'm telling you that you will not do as good of a job as an attorney.
You just insulted me.
Okay. Do you understand that if you choose to waive your right to counsel, that this would be a permanent decision, and that absent exceptional circumstances, you would not have the right to have counsel appointed again in the future?
Sure.
Would you like to consult with an attorney before you make a decision in this regard?
No, maybe you could appoint advisory counsel, but I wish to stand before you on my own 2 feet.
Okay.
And I wish for the law of justice, or the 12 that is going to preside the case, to hear the truth. Okay, I wish not to do persuasive words and flattery speech meant to beguile the minds of innocent. I'm not innocent. I was born a sinner who suffered a traumatic brain injury and studied to show myself approved so I could stand before you, or be forced to sit before you and give an account on what I would like. Okay, and all this beguilement that you're trying to persuade me to enter into the corporate entity, I wish not to do. Okay, I refute the corporate entity. Okay, period. Okay, because I was created free. I don't know who gave you the authority to tie me down. Period.
All right. Well, Mr. Lavity, today you have told me that you do not understand English, that you do not understand me in some circumstances, that you do not understand that you have a right to have an attorney, that you do not understand that if you
counsel upon
you're right, Mr. Lavity, I am going to appoint an attorney in this case.
Force counsel upon me, which is against your position in that chair that you're sitting, because you don't make the law, you're supposed to enforce the law. Okay, so therefore you forcing counsel upon me breaks the law and the oath that you swore to hold and uphold, period.
I understand that you're disappointed with my ruling, Mr. Lavity, but I cannot conclude that you knowingly, voluntarily, and intelligently waived your right to counsel in this case.
I'm incompetent because you just deemed me incompetent before the court.
I deem that you have not knowingly, voluntarily, and intelligently waived your right to counsel. You've told me today that you don't understand that you have a right to be represented by an attorney, that you don't understand what an attorney would do.
Again,
you
Your
don't,
Honor,
Mr. Lavity, that you don't understand what I'm saying most of the time.
I wish not to have counsel.
I understand that, Mr. Lavity. Unfortunately,
okay, in the Colorado Revised Statute, in the beginning of the book,
Mr. Lavity,
I have the right to refuse counsel.
Please stop talking.
I asked to refuse counsel, and now you and your undelegated authority are usurping the authority of the higher counsel that you swore an oath to uphold and represent. So how does that work? How can you do that? It's impossible. You cannot break the law in order to uphold the law. That's a double negative. Where's the positive in that? There's no positive. Okay, you think I'm ignorant. I've been doing this all my life, Your Honor. All my life, I've been accused of this, that, and the other. Okay, you guys send me away the last time for 10 years on a false allegation, and I filed the affidavit, and I filed grievances, and I submitted it to the clerk. Where is the copy? I have copies in my possession still of the things that I submitted to the county clerk here in this state, because you guys sent me away this last time for 10 years.
Ms. Tebow, I'm appointing the public defender's office in Mr. Lavity's case at this point. Can you indicate whether or not your office has a conflict within the next few days so that we can sort out an attorney for Mr. Lavity?
Yes, Your Honor. Had ADC already been appointed in this case?
ADC has been appointed in the past, but
Oh, I see. Okay.
no attorney was appointed. Mr. Lavity refused counsel at the bond hearing I am finding today that I cannot conclude that Mr. Lavity has knowingly, voluntarily, and intelligently waived his right to counsel in this case. He's indicated that he doesn't, frankly, understand his right to counsel. He has indicated.
When did I say that? When did I say
Mr.
that?
Lavity, please don't. Mr. Lavity,
Your Honor.
Mr. Lavity,
this is
you need
my
to.
right. This is my right, Your Honor.
Your Honor, we will do a conflict check and I will get entered provided we don't have a conflict. If we could come back on, I'm worried Friday might be a little bit too fast. Oh, could I have the white noise one more time? Is there any way the court could have us come back off docket on Wednesday for a continued formal filing and bond hearing?
I'm in trial.
Imagine that. Persuasive words.
Can we come back on Tuesday, the 11th at 9 o'clock instead?
I'm available for that.
Mr. Sullivan, Tuesday, the 11th at 9 o'clock?
Yes, Your Honor.
Deputies, will that create an issue for you all? All right, Mr. Lavity, we'll bring you back Tuesday, the 11th at 9 o'clock. That'll be off docket. My Wednesday is too busy to address it, so we'll bring you back a day earlier than what you were asking. If circumstances change and you can address the issues that we need to address, I'm more than happy to reconsider your request to represent yourself, Mr. Lavity. But today I can't conclude that you knowingly, voluntarily, and intelligently have waived your right. And that's the first step in order to allowing you to represent yourself.
Okay.
Your case went all the way up to the Colorado Supreme Court, and that's what they said.
And they failed
Okay.
because
I understand that you feel that way. Talk to Ms. Tebow about it. She's a very, very good attorney, and she will work very hard on your behalf in the interim, okay? We'll see you back here next Tuesday, September 11th at 9 o'clock. Thank you.
may I move, Your Honor?
Yes, you may. Thank you. Gary, let's see, Hope Montgomery.
First case, State of Indiana versus Justina London, 46 D04 2607 F6875, 2608 F6906. Ms. London appears by video without counsel. We're here for initial hearings in both cases. Ms. London, were you advised of your rights before court today?
Yes.
You understand what your rights are in each of these cases?
Yep.
You have any questions about your rights today?
Nope. Stay locked up and be black, right? Got it.
What's your mailing address?
I don't have one. I was using the Salvation Army, but every time I go up there to check my mail, I end up in jail. So I don't know what to do with that.
You have a cell telephone number?
Nope, sure don't.
All right, please listen. Mr. Fredoso is going to advise you of the charges and potential penalties in each case.
Thank you, Your Honor. In cause ending F6906, there's one count alleged possession of cocaine, a level 6 felony. That count reads on or about the 4th of August, 2026 in LaPorte County, Indiana. Justina London did unlawfully, knowingly, or intentionally possess cocaine, pure or adulterated, without a valid prescription or practitioner acting in the course of the practitioner's professional practice. That is a level 6 felony. It's punishable by a sentence of between 6 months and 2.5 years, with 1 year being the advisory sentence, as well as a fine of up to $10,000. In cause ending F69, let's see, I just read. In cause ending F6875, there's one count alleged. It's intimidation, a level 6 felony. That count reads on or about the 24th of July, 2026 in LaPorte County, Indiana. Justina London did unlawfully, knowingly, or intentionally communicate a threat with intent that another person be placed in fear that the threat would be carried out, and the threat was to commit a forcible felony, specifically arson. That count is a level 6 felony. It's punishable by a sentence of
But
between
nobody got arson, so that's
years.
not really.
with 1 year being the advisory sentence, as well as a fine of up to $10,000.
He said, she said, I thought it's not inadmissible in a court of law. So yeah, Brian Beal, he's pretty much fired as far as this goes 5 years and he still ain't figured out one case. Where are you?
So, Miss
Is he
London,
up in there? Is Brian Beal up in there? Because he fired like a motherfucker.
Miss London, do you understand the charge for each case and the potential penalties?
Yeah, I sure do. Yes, sir.
Right. I'm entering preliminary pleas of not guilty on your behalf to all new charges in both new cases. What's the date for set for? September.
And I just paid an extra $300 to get out last time, and I wasn't even supposed to pay that. So I'm about sick of this.
All right, the court's entering a no contact order in favor of Christopher Groves. You are to have no contact with him whatsoever.
Who is that?
Person by letter, telephone, texting, through the use of any app, through any social media, through the use of computer, through any third party, none at all.
Who is the person you're talking about? I don't even know him.
The alleged victim in 2607 F6875
Okay, thank you.
alleged you threatened him.
Some honky, right. Anyways, moving right along.
Your last warning. This is my courtroom. I determine what we do and don't do in here and how we do it. If you interrupt me again or tell me to move along, stop with the hands or I'm going to hold you in contempt. All of your cases are now set for September 11th, 2026 at 9 a.m. in front of Judge Friedman.
I'm not going with Judge Freeman, so you can forget that. I need another judge because that ain't gonna work. No, I refuse. I refuse that judge. No.
How many cases does she have?
No, every time she doesn't do it right. And no, all of my cases are out of city. Why if I gotta keep going to court up here?
Has 8 cases pending.
Right.
She's been out on bond 6 different cases and now she has 2 additional charges. Her bond is set at $3,000 cash. You're excused.
Fuck you.
You can bring her back.
Oh, God.
I told you. I tried to tell you.
$3,000. Fuck him.
He just said, what?
I'm not. No. I don't give a fuck. I don't know that nigga and I don't care.
Your Honor, unless you want us to pull her over using physical force.
Shit, send this nigga. No, $3,000. I got it. Get the fuck out of my.
You can tell Miss London she can sit back down like a lady and apologize to the court, or I'm going to hold
I'm
you.
not sorry. I'm not
I'm going to
sorry.
hold you in contempt.
I'm not
Right
sorry.
now, you're at 60 days.
What does that mean?
That means you're going to spend jail time.
Oh well. Are you done yet?
No, I'm not finished.
Oh, well, good. Keep talking.
I told you not to tell me what to do. This is my court.
I didn't tell you what to do. I tried to ask you a question and you act like your fucking ears don't hear.
Watch your mouth, Miss London. The court finds you in contempt for swearing at the court and interrupting these proceedings. You're sentenced to 60 days, LaPorte County Jail.
Good. Are you done? Because I can't stand the sound of fucking crackers. I gotta go. Gotta go. Can't do this. Sorry. No. I don't take orders from whites. Sorry.
Now you're at 90 days. You're
Well, good.
excused.
Keep going. Because I never get out of this motherfucker anyway. I don't care. Nigga, I don't care. So what?
Mute her. You're gone. Go. Put her back down.
You want me muted?
No. Put the jail on mute, please. You think this is a game, Miss London? You think you can flip me off?
I think that you playing with my motherfucking life.
You think you can
I
flip
think
me
that
off
you
and
don't care. I
continue?
think, excuse me, you want a real answer to that, or are you just asking a rhetorical question that you don't want no answer for?
No, I'm asking you. You think you can?
I think that you're playing with my life. I think that this is overrated. I think that all of you guys are in on it together, and I think that I have never had proper representation. I think that you're going to keep on going until you are satisfied. I think that when you go home tonight and you lay down, it's not going to fucking bother you.
No, it's
about
not.
what the fuck you put people
Where,
through.
Ms. London, so now you're up to 120 days. You're excused.
I don't care.
Okay, good, leave.
Are we done?
Yeah, we're finished. Go.
Mr. Hervey's here virtually, is that right?
Oh, yes, that's correct. I apologize.
That's okay. All right, the protocol 25T3907, Mr. Hervey is present virtually this morning with Ms. Hanaclaw. Ms. Hanaclaw?
Defense is ready to proceed, Judge.
Oh, that's right. He's out of state, right?
He is.
Oh, no, he's not represented. And then real quick, yep, Mr. Moore, thank you. Mr. PG?
Yes, Your Honor. I believe we were here the last time. People asked for continuance of this hearing due to Officer
Kuchenkamp.
Kuchenkamp conflict. Court granted this motion today, and people did subpoena again Officer Kuchenkamp. I sent email to him about because he was the reason this was continued. I have still not heard from Officer Kuchenkamp. Yesterday after trial, I tried to contact him. To date, I saw that he viewed the subpoena but did not accept it. And as at 11:26, I still have not heard from him. At this time, people cannot proceed without his testimony based on the reasonable suspicion and the suppression of express consent motion defense counsel has filed. So at this time, people are moving to dismiss this case.
Okay. Yeah, well, if you're moving to dismiss, then I'll just kind of.
All right, well, let me clarify the record. People are going to concede to the motion, the defense counsel. Yes.
Okay, that may ultimately end up in a dismissal, but
That's right.
I think that would be the function of the court today, finding that this is the second motions hearing. Sounds like the DAs are doing what they're trying to do here. It's unfortunate that they're being ignored from what it sounds like. So at this time, the court will grant the defense motions for will suppress the stop due to lack of reasonable suspicion. I'll suppress the roadside tests as well as express consent and the warrantless arrest. And then we'll go from there. I don't think that leaves the people with a whole lot, but they don't have to make that call here today.
That's right.
So, Mr. Hervey, we're still set for status on September 2nd. That may change. I need you just to stay in touch with Ms. Hanaclaw, and you can appear virtually for status conference, okay?
Okay.
And real quick, Judge, could I just clarify the record? What I heard from Mr. PG is that with the motions filed and now everything being suppressed, is there a motion to dismiss at this point?
Not at this point.
It may be
It
following.
may be filed. Yeah. I just need to talk to him.
Okay. Troy was here and I thought. Oh, he is here. Yeah, I thought that
I think what we want to do, and we'll have an answer probably by the end of the day. I want to reach out to these troopers because this is on them. Ultimately, I think we're all going to get to the same conclusion, but I want to have that conversation with them. The court's suppressing all of the evidence in this case.
And that really is the only mandatory function here today. So I'm going to grant the defense motions to suppress. At this time,
What the hell is Zach thinking?
can't dismiss the charge. I think we all know where that leaves everybody, but the people have a right to follow up on that and reevaluate their situation. So, Mr. Hervey, as of this moment, we have status on the 2nd of September. I am going to authorize you to appear virtually for that, but I also really encourage you to call Ms. Hanaclaw here and stay in touch with her because that could change. Okay, sir?
Sure. Yeah, I'm just trying to get an understanding. So we're giving more time for this officer to abide by the rules of the court.
No. His failure to appear a second time has resulted in me granting your attorney's motions to suppress, and the DA conceded them. What we're giving more time on is for the DA to decide how they wish to proceed forward with the charges, okay?
Yes, sir.
Because he failed to appear a second time, I am granting the motions to suppress.
Okay.
Does that make more sense?
That makes some sense. Yes, sir.
All right. Ms. Hanaclaw will walk you through the whole thing, and you'll probably hear from her very shortly. Okay, sir?
Thank you, sir.
All right. You're welcome, Mr. Hervey. Thank you, sir.
You have a good day.
You too, sir.